Yay. All right, folks, we are loading people in here. We're going to give it 1 minute. I don't see myself on the screen, but hopefully you guys can all see the screen. Excellent. I can't see myself. So Alex or somebody else, can you just affirmatively say you can hear me?
I can hear and see you, Brian.
Okay. Um, so first off, I want to welcome everybody to the webinar on navigating tariffs following the Supreme Court ruling. As you can imagine, this is a hot topic. It's literally the thing that we talk about as an EPR all of the time at every single conversation I've had, including my dining room table. So excited to try to explain some of this, answer some questions as we get forward. For those that don't know me, I am Brian Wild, Chief Government Relations Officer at NAW. I am going to kick this all off, and then I'm going to hand it off really quick to two other people who are going to do most of the talking. But first off, this is being recorded, and then within the next day, 24 hours after this, you will get a link to be able to watch the recording. It'll be sent out to you automatically. I want to emphasize that we really do encourage audience participation throughout this presentation. There's a Q&A function that you all should be very familiar with in Zoom, so please use that, and we will try to answer questions. If we don't do it during the program, we'll have a period of time at the end of the program to answer those questions. And so with that, I'm going to introduce really our two presenters here. So first off is my colleague, Alex Hendry. Alex is our Vice President of Government Relations and does economic policy for us, tax, trade. He's been the lead on these, and really the head communicator that we have in talking to the White House and Congress on tariffs in particular. And we are joined by Eddie Hayes, and some of you may remember Eddie. He gave us a presentation on tariffs before. We work a lot with him. He is a partner with Leek Anderson, and he is an active in the corporate and transactional matters. He leads his firm's international trade and business practices, and really leads in the areas of freight and logistics contracts, supply chain, third country outsourcing arrangements, all of the things that we as wholesaler distributors do. And so Eddie is our expert that's going to kind of walk us through that. So with that, Alex, lead us on.
Yeah, thanks, Brian. And thanks, Eddie, for joining us. So let's kick it off. First of all, let me just set the table before I kick it over to Eddie to offer some thoughts. So first of all, we're going to go through the Supreme Court decision that came out on Friday, run through some of the kind of what to expect next on tariffs, what the administration is looking to do in that space. Thirdly, we're going to give you some insights into what is happening in DC, what the administration is thinking, and what congressional Republicans and Democrats are looking at doing. And then lastly, Eddie is going to walk through kind of the refunds, what everyone should be knowing and thinking about, and how to approach those. And lastly, we'll kick it off for questions and comments. Also, wanted to reemphasize, we'll try and also get to questions as they come in, so please feel free to ask questions throughout the presentation. So with that, Eddie, as everyone saw last Friday, there was the long-anticipated Supreme Court decision on IEEPA tariffs. So give us a brief summary of what happened, what jumped out to you. First, basically, what tariffs are covered and what are not. Were there things you were surprised about or things you felt were more relevant or more set more precedent? Open it up to you.
Okay, thank you, Alex, and thanks to Brian as well for giving me the opportunity to speak to you all today. I want to compliment NAW for staying on top of this. You guys have been following this, for well over a year now, obviously, and it's a really good service that you're providing to your membership in an area that not everybody understands or wants to understand. So I think you guys are doing a fantastic job. So I really appreciate the opportunity to speak to some of your members. So. Yeah, Alex, the decision was rendered, and I've got just a snapshot of it there. But if you go to the next screen, we'll just kind of give you a brief overview of the case. Obviously, the result of the case is what matters most to you all as businesses. But from a legal perspective, the opinion was issued by Justice Roberts. It was a 6-3 opinion with 3 dissents, and it explicitly says that the IEPA statute does not authorize the use of tariffs for addressing the emergency situations that the statute provides for. So it was a pretty resounding decision that puts to bed the question of whether or not the executive has this authority. And many of you may be familiar with the constitutional setup, but Congress obviously under Article 1 has the exclusive authority to deal with tariffs and to raise funds for the federal government. And unless there's a specific delegation of authority from Congress. And the court went into some discussion of what they call the major questions doctrine. And in those types of cases where it's a major question of constitutional delegation of authority, the delegation has to be absolutely explicit. And of course, the court found that in this statute that the words regulate importation do not authorize the president to use tariffs. And so it was a pretty straightforward and well-written opinion, I think. And of course you have some of the justices dissenting, but a 6-3 decision is pretty clear, and I think that's going to be precedent for a long time, and it could impact other cases as well that we'll talk about here in a minute. Now, what the case doesn't address is probably one of the more important things, which is it doesn't address remedies. There's no instruction about whether or not the courts have to issue refunds to people, and it doesn't address how that process may take place. So that leads it back to the lower courts. But I reference in there the Customs and Border Protection message number where they ended the IEPA collection. So those are no longer being collected. The parties in the lead cases have now sought the lower court's guidance on next steps, because as I said, the Supreme Court decision doesn't go into that. So there's been a motion filed by the plaintiffs at the Court of Appeals for the Federal Circuit in DC to issue a mandate to the lower court, which is the Court of International Trade in New York, to begin the remedy process. The government, their response is due today. I haven't seen that response just yet. But also, I was mentioning to Brian and Alex before we jumped on, the parties have also filed a motion at the Court of International Trade to set a status conference to get the ball rolling. So I think this is going to happen sooner rather than later. That is an important point because later on we'll talk about what folks are seeing in terms of the refunds. Some folks are getting requests to sell their refunds to venture capitalists and things like this. And so the timing of that process, I think, is important for you all to consider if you're receiving those types of inquiries and you're considering whether or not to offer your refunds up for sale. So that's where things stand. Alex, if you could just jump to the next slide.
Yeah.
Anyway, and so we'll revisit the tariff refund issues in a little bit. Alex, did you want to jump in here and talk a little bit about what you were seeing on the Hill?
Yeah. So I think that's a kind of timely we'll get to refunds in a little bit. So first of all, I think it's in the wake of this, there's a lot of confusion. I think it's we have midterms coming up. The first primaries come up in the next week or so. So we're very much in election season, and this has now both become a legal issue, but a political issue. For the first time, Democrats are really trying to hone in on the refund issue as a affordability issue. They're really running on affordability and inflation. So they've introduced a whole set of bills demanding refunds in 90 days, 120 days, 150 days. They're also pushing various governors have called for the president to refund consumers based on the tariffs. It kind of remains to be seen uh, you know how strong that Democrat opposition to tariffs is. In the first term of in Biden's term, there was no effort to roll back any of Trump's first tariffs. So there's all this level of comfortability with tariffs traditionally on the Democrat side. But from the administration, I know Eddie is going to get into 122s and 232s. But they're kind of in this they're stuck with all the trade deals they negotiated, in part using IEEPA tariffs as a stick to get other countries to the table. The United Kingdom and Australia negotiated 10% tariff rates, which they then forcefully, if media reports are to be believed, forcefully went to the administration saying you can't impose 15% 122 tariffs on us because we already cut a deal with you, which has kind of led to this confusion in the last week where Trump has said he wanted 15% tariffs. Now it's only 10. I think the latest, and Eddie, correct me if I'm wrong, I think the latest is that 15 is still on the table for countries that might be bad actors or whatever Trump determines. I think this is their attempt to use the tariffs as a stick. Eddie, do you want to go into 122s and 232s?
Sure, I'll be happy to. And thanks, Alex. I actually wasn't aware that there were some legislative efforts to force the government's hand. So I appreciate you sharing that. I'll be interested to read some of those bills. And it may just be posturing politically, but obviously, as you mentioned, the affordability issues are going to be key in this primary. So that's a really good insight. So we shared the good news about the IEEPA case. Depending upon your perspective, I guess some people might think it was incorrect, but it is what it is. But that's not the end of the day here. USTR and the administration was signaling well before the case was decided that they had alternative plan Bs in their pocket, ready to roll out if the decision was adverse, which of course it was. So the first thing we saw was the issuance of Section 122 tariffs, and that's a statute that authorizes the use of tariffs of up to 15% for 150 days to address certain balance of payments deficits or significant dollar depreciation. The statute has never been utilized before, and it's never been challenged. And as Alex mentioned, it authorizes up to 15%. The current proclamation from the president and the customs guidance, which I've referenced here in the slide, is 10%. So as of now, they're collecting 10% duties, and then that'll be from February 24th through July 24th. The one caveat there is that Congress can extend the period of those tariffs, but Congress would have to vote on that. And I'll defer to Alex and Brian on the prospects of that. My sort of sense is that would be very difficult because these tariffs are not entirely popular even throughout the Republican caucus. So I think you'd have some Republicans that might defect if it were to get to that point. And again, I'll defer to Alex and them, but I don't know that the administration wants to put their Hill colleagues under the crossfire of that issue by asking them for an extension. So that's where we are. And
I think one of the interesting, to jump in real quick, one of the interesting dynamics is that July 24th date is right before their August recess, where they leave for 6 weeks. So I think there's very little will to deal with that. I think Trump has mentioned doing $2,000 tariff rebates in the past. He's kind of backed off on those. But you could possibly see him bring those back if the economy isn't doing great and his the midterm election prospects aren't great. But I agree with Eddie that I think there's very little to address these in any way in Congress.
Yeah, no, that's a great point about the recess. I didn't even think about that. So it just in some of the nuts and bolts on the 122 order, of course, it stacks on top of any 232 or 301 duties that might be applied. There's an exclusion for USMCA originating goods, which I found very fascinating because there's no similar exclusion for other trade agreements. And I think Alex or Brian mentioned that the administration has struck deals with the UK and other countries that don't enjoy this exclusion. And in certain circumstances, with the 10%, they're now going to be paying above what they agreed upon in their, if you will, free trade agreements with the administration. So that's a bit dicey. And that's an issue that remains to be clarified. The USTR went on record saying that they were trying to mimic as best as possible the IEEPA tariffs. And so that would probably be more in tune to the issue of whether or not it goes up to 15% for certain bad actors or other countries that aren't negotiating with the administration. So unfortunately, I can't give you any definitive guidance on that, but I would suggest watch the space if you're importing goods or in the chain of custody of goods that come from some of those countries where there's been an agreement reached, because you may see some relief there. But just as an example, the EU negotiated a 15% ceiling in their agreement. They have not ratified it over in the EU yet, and they're threatening to withhold that because there's now, with the 10%, a lot of categories of goods that are going to be over the agreed upon 15%. And the data that I read suggests that there's around $5 billion worth of EU goods that would now go beyond the previously agreed ceiling. So I expect to see some development there in the near term, and possibly some additional guidance from customs on that, maybe even another proclamation or EO from the administration. So hold the phone on 122. There's going to be some developments there, but for now, the 10% is obviously being collected, and you all, I'm sure, have access to tariff simulators and things of that nature that you can take a fresh look at. We've been doing that for clients. And a lot of our clients in particular are getting a significant discount because of the 10% 122. So it just depends on your particular good, where it comes from, what the classification is, because of course the general duty rates apply as well as the 10% and any others.
Eddie, we've gotten a couple questions on 122s, and why don't we knock those out real quick? Can the president simply reissue the 122 tariff after the first 150 days?
No, because it's meant to be a temporary ability. It's meant to temporarily address these balance of payments problems. That's my opinion, Alex. Again, this has never been tested. So I presume the president could, but Congress was very specific in limiting that authority to 150 days. And if I didn't mention, I would expect that this tariff order will be challenged in court, because there's an argument as to whether or not addressing a trade deficit really is a balance of payments or a dollar devaluation problem.
Okay. That's perfect. That was actually one of the other questions, whether 122 is legal in this instance. And then the other question, 122's clarification on 122 stacking on top of 232s.
Yeah, so the 10% 122 tariff would be in addition to any other special duties that apply to your goods. So if you've got steel and aluminum duties under 232, which we'll talk about in a minute, then those would apply on top of the 10% 122 tariffs. Now, there are two appendices to the president's order with certain exclusions for certain goods. So you may want to check those categories that are listed in the appendices to see if your goods are excluded. But otherwise, you're going to pay the full 301, the full 232, and the 122.
Great.
So just moving on, the bigger arsenal in the administration's toolbox is Section 301. And Section 301 generally is utilized to address what are deemed as unfair trade practices. It's a broad grant of authority from Congress to the executive branch. It has been challenged in court and upheld. It's also been challenged at the World Trade Organization. So So that that regime is on solid ground. And the USTR has already notified the public that it's initiating expedited investigations covering most trading partners. So this is their attempt to try and fill the void and the vacuum left by the elimination of the IEEPA duties. The unique thing about 301, however, is you have to have a notice to the public. There has to be a public comment period. They hold hearings to take to receive evidence from companies. So if you have a trading partner that is potentially going to be hit with these 301s, you may want to weigh in. And I'm sure Alex and his colleagues there can help you guys in that regard. But those investigations, Ambassador Greer has said they're going to be expedited. I don't know what that means because the statute is pretty clear about the time period that has to take place. But he probably just means that they're going to do their work on an expedited basis and get these things teed up fairly quickly. There are also currently ongoing several 301 investigations on China, Brazil, Korea. So we expect those to be ramped up as well. Again, to try and fill that gap or that void between what IEEPA had in place and what 122 allows. The biggest question is, can they get it done in 150 days? And I haven't done a deep dive on the timing of the 301 process, but I'll be happy to share that with everyone later because I assume their goal is to get those in place not just as quickly as possible, but presumably right after the 150-day expiration of the 122 tariff. So watch that space, and I'll just mention 232, Alex, and then I'll pause. The 232 national security regimes have also been challenged in court and upheld. So this is another solid foundation for the administration. And there has been some indication that, in particular with the steel and aluminum order, that they may impose tariffs on the full dutiable value of the goods and not just simply the content, the steel and aluminum content. So I know that might impact a lot of your members pretty significantly. So you may want to watch that. I think in order to amend that order, they also have to provide a public comment period. So Alex and his colleagues will be watching that space for you all in case you want to weigh in. So with that, I'll pause, Alex, for any questions on that, or you can get into it.
Yeah, I would just give a plug. NAW has commented on a number of 232s. So if there are new issues that come up, we're certainly willing to engage. And then I would I saw an article, I think earlier today, mentioning that the administration might do a whole set of new 232s on things like telecom equipment, chemicals, cast iron, and large batteries. So it seems like that's also an avenue that they might look at moving into. Why don't we go to refunds, since I know that's something that is on a lot of people's minds.
Sure. Yeah, happy to do it. So the Court of International Trade is the court of first instance for customs and trade matters. It's got, and it has asserted, residual jurisdiction over all these IEEPA claims. And as you've probably read, there's a host of businesses that have been filing lawsuits to preserve their rights. Most recently and notably, Federal Express filed a lawsuit. I think Costco was a big one earlier on. And so during the course of the initial cases, there was a question, and this is getting way into the weeds, but there was a question about whether or not the court had the authority to issue refunds, and the government judicially admitted in those proceedings that it concedes that the court does have such authority, and that they would be judicially stopped from arguing that later on. So the Court of International Trade will have the authority to direct refunds if it so chooses, and if it believes there's merit to the plaintiff's claims. I was talking to Alex and Brian earlier. There's prior precedent for refunds being issued from customs in cases where Congress has retroactively authorized some statutes, and folks had paid duties that were then exempted, and customs did a very good, efficient job of issuing refunds, but that is not this. This is $134 billion in collected duties. So I don't know. I can't speak to Customs and Border Protection, but especially in light of lean government and things that have been happening in that regard, I don't know that they have the resources to handle that workload. They very well might. It might all just be automated through the ACE environment, but I would suspect that we might see a special master or something like that get appointed to handle the logistics here, because it's such a large amount of money. And I also mentioned this earlier. There's a 2-year window to file the lawsuits. So some folks still have claims that they haven't asserted. There's certainly a risk with that. Some of you all may be questioning, well, do we need to go run the court? Most of our clients have been filing lawsuits just in order to preserve their rights, because it's not cost prohibitive. But it's unclear what may happen. I could foresee a situation where they say, okay, prove that you are an importer of record and you paid these duties, and then there's a procedure by which you're able to claim a reimbursement. But only the importer of record is entitled to these refunds. And so I guess my best advice would be just to analyze your current situation. If you think that you're owed some potential refunds, you may want to consider protecting your rights. And I did a quick look of the 134 billion, 38 billion that was collected from goods originating in China and Hong Kong, 6.5 billion Mexico, 2.4 billion Canada. Those were the next two largest numbers, which, of course, as Brian and Alex will tell you, that's USMCA. So that, the USMCA countries are very important trading partners for our country. And I know Alex and Brian will talk to you a little bit later about the ongoing USMCA renegotiations, if you will. But that's a very important part of our trade world here in the United States. So a lot of folks are preserving their rights at the Court of International Trade. Excuse me. And I'll be happy to try and answer some questions about that if we have them at the end. But the second part of that is something that I'm sure many of you are wondering about is, well, who is entitled to the refund? What if I have a customer or a client who passed them on to me, or I did the same to someone else? What's the impact going to be there? Obviously, that all depends upon where you are in the supply chain. And Alex, if you jump to the next slide, I'll give you all an example of something that I saw from a client. They received this from one of their suppliers saying, hey, you passed on some of this stuff to me. I want you to assign your tariff refunds to me. So I mean, this was hot on the heels. This was probably prepared in ready and waiting for the Supreme Court's decision. So some of you, if you haven't seen these yet, you might. But I would carefully consider it before you agree to these things. Obviously, your businesses are different, and your business relationships are the most important thing. And some of you may already have agreements in place with customers or with folks up and down your supply chain. So just consider that issue, because if you haven't heard from it and there's significant monies potentially due, you likely will. And then the other thing I want to mention, Alex, and I'll pause, is a lot of folks have been asking me, they've been approached by venture capital and other folks who want to buy their refunds. And that's when I was talking about earlier about the process. A lot of folks are under the impression that this may take years, and therefore they'd rather see the money now and take a slight haircut on the offer. I don't think it's going to take that long. That's just my personal opinion. We haven't seen anything yet from the court. Like I said, they do have that status conference motion. So I would imagine within the next 5 days that will get set, and we might get some indication as to what may take place. But I think Customs, and at least from what USTR has said on the record in the past 2 days, they're ready. They're ready to issue refunds if the court orders it. So to the extent that's a consideration for you, if you get approached in these things, the only thing I can tell you right now is that I anticipate it happening sooner rather than later. So if that helps with your decision making, that's, for whatever it's worth, I offer that. But we'll know more soon. So there's no rush to do something like this, in my opinion, at this point. And then the other part of that is, as I mentioned, only the importer of record is entitled to the refund. And I'm not so sure an agency agreement or a power of attorney with some third party then allows them to get the refunds. I just am not familiar with that process enough to know whether or not Customs or whomever handles these things would allow that, because if not, that means you're going to have to be involved anyway. right? You're going to have to be involved in providing the data and what have you. So you're going to be investing time and resource no matter what. So I would just bear all that in mind and make sure you have your brokers preserve any and all customs records and customs entries during the time period of IEPA, so that you have that at your ready in case the court acts swiftly. So I'll pause there, Alex, and let you guys.
Yeah, Eddie, one question I had, there's been kind of speculation that the administration would do everything they can to try and slow walk or even minimize refunds. Is there legal, do they have any kind of legal tools they can use, or would this just be kind of them again testing the boundaries and kind of trying to delay?
Yeah, I mean, it's now in the hands of the court. So the judicial system is going to take preference over any political decisions and things like that. I'm not aware of any statutory or other tools that would allow the administration to pause these things. I do recall, and I'm sure everybody on the webinar recalls, the government talking about, that this is a really important part of reducing our trade deficit, and that reimbursing this money, could cause some problems in that respect. But I'm not aware of any tools other than just the judicial process. And like I said, I think the Court of International Trade is going to move fast and expeditiously. It's a very efficient court. They've got great judges there, and I think they're going to want to get this out there. And then Alex and Brian, the political side of that, I'll defer to you guys on. If they do decide to slow walk it, how does that look? Particularly in a primary season and things like that. But that's the best answer I think I can give on that.
Great. Well, we have a number of questions that have come in, so I think we'll kind of go to those to start with. So first of all, can you kind of summarize, Eddie, what kind of the key deadlines a business should be paying attention to regarding the whole refund process, over the next coming weeks and months?
Yeah. So, there's two different sort of deadlines to bear in mind. The one deadline is the administrative process through Customs and Border Protection. And once the goods are liquidated, you have a certain amount of time before you can protest that decision. That's an administrative process. That's one thing, but there's a significant question out there as to whether or not Customs even has the authority to issue refunds in a situation like this under that process, under the protest process. So for that reason, folks have been jumping into court. I've got some clients who, out of an abundance of caution, did both. They filed their protest timely, and they also had me file lawsuits. I think the lawsuit route is the safest because the government has judicially admitted that the court can order the refunds, whereas the customs side through the administrative process is still a little bit uncertain. So just make sure you pay attention to when your goods liquidate, collect those records, like I said. And if you're at all concerned, there's a lot of lawyers out there who can file these lawsuits at the Court of International Trade. It's a $400 filing fee. It takes us maybe an hour or so to prepare them because the allegations are the same. So it's not cost prohibitive if you want that security, that your rights are preserved, and maybe there's going to be an order. In other words, if you're on record in a file suit, your payments come first. It's still unclear as to how that will work. The second thing, just to conclude, is these reimbursement issues. If they're going to come up with your business clients up and down the supply chain, you may want to think about those issues and be prepared from a business perspective as to how you might respond to someone who asks you to assign your rights, or vice versa. If you want to approach someone to potentially reimburse you, you're going to see a lot of import front loading in anticipation of the 301s coming down. So I anticipate a lot of goods that are going to start flowing into the ports here. I haven't looked at marine traffic lately. I don't know what the shipping business is up to lately. I know they were having a hard time, with supplies, post-COVID and things like that. But your shipping costs may be something you want to take a look at and consider, because a lot of folks are going to try and get ahead of these new 301s. So just continue to monitor those, and I would rely upon Alex and Brian and the folks at NAW on the public policy side and what's going on with USMCA, because those are very important ongoing negotiations. And I guess where I'll leave it is, Congress has not really had to assert much authority they've allowed the administration, obviously, to do these things. Congress could have always jumped in because, like I said, Article 1 gives them the exact power of the purse in this regard. And so I was just anxious to hear and surprised to hear about Alex talking about those bills to try and get this process going forward. So if for no other reason, I would watch that space just to see how Congress tries to now sort of reassert its authority, if you will, in this area. So I'll stop
Yeah,
there.
I think on that point, I think we expect Democrats will try and force votes wherever possible on these kind of any kind of refund bill, tying it again to affordability and inflation. I think sadly there's very little will on the Republican side to do anything on trade or tariffs that is not explicitly blessed by President Trump. And given they hold the majority, we don't really expect much. You might see some Republicans who are not running for re-election speak up, but past that, very little. And I know you touched on USMCA negotiations. That's something that I think businesses should be aware of as kind of a potential upcoming fight. Around the summer, President Trump has repeatedly said he wants to either renegotiate or withdraw from the United States-Mexico-Canada agreement, and negotiate bilateral agreements. I think one of his most recent comments basically said, "I don't care about North America. I care about the US." And this agreement, even though he negotiated it, in his view, doesn't really do much for the US. So that will be something that I think they very much seek to either renegotiate or completely throw out and negotiate new agreements. We have a couple of other questions as well, Eddie. One is one company says they have customers sending them demands for tariff refunds, even though they are not the importer on record. Do they need to be concerned about litigation kind of along the supply chain targeting them for refunds?
Well, that's an interesting question. Yeah. Well, if they're not the importer of record, then technically they didn't pay the duty. In a pure sense. Now, maybe they did through pricing structures and things of that nature, but yeah, only the importer of record is entitled to get a customs refund. And so I hadn't thought about whether or not there'd be any legal liability otherwise. I guess it would be under some sort of contract theory that, you pass this on to me and now I have to, now you're getting a refund and I'm entitled to it. Unless there's a contractual arrangement that sets that out, I wouldn't be overly worried about it, but that never stopped anybody from filing a lawsuit, of course. So I would just check and double check your supply chain agreements, and maybe there's an argument they can make under force majeure, or who knows. But I hadn't heard that one yet. But I wouldn't be overly concerned, I guess, is my initial reaction, unless there's a contractual liability.
Okay. One question on 232s. You mentioned expansion of steel and aluminum. Do you anticipate or have any predictions on expanding other 232s? The question specifically mentions copper, but I think the same could apply to a lot of the other ones: timber, semiconductors, auto parts. I know you focused a lot on 301s. Do you see that being the where the major activity is, or do you also see something on 232s?
Yeah, so the 232s, as you just mentioned, Alex, are pretty sector and product specific: steel and aluminum, lumber, copper, and all these other things. So I don't know how much ceiling room they have left under those orders to ramp things up. So it would depend upon the particular 232 commodity and what the tariffs that they're charging are, as to whether or not we'll see that. We'll certainly see new 232 investigations, I'm sure. I think the administration even mentioned seafood or agriculture. I can't remember all the details, but until we see a public notice, it's anyone's guess. I think the 301 would be more concerning to me because those are country based, and those can tackle the trade practices of an entire country at one time. And the USTR Ambassador Greer has said he does not think that the 301s will go above the IEPA levels, because they were comfortable with the levels they had reached in the IEPA tariffs, but he didn't commit to that, obviously. And so worst case, I would think under those 301s, you may get back to the IEPA levels that we saw before. I think they'd be hard pressed to go above that. But
Mhm.
it's a full investigation, and when they do these 301s, they look at all trade practices. So it may not specifically be in your sector, but if there's what they deem unfair trade practices in other, it could bleed over into your sector in terms of tariffs. So that's where I expect most of the potential pain to come. But again, I'm not ruling out new and elevated 232s.
Great. This one might be a question more for Brian and I than you, but I'm gonna throw it out there. Brian, maybe you have some thoughts. Should importers be concerned about retaliation for filing a claim to get their IEPA refund?
I uh, well, I think it's interesting. I mean, we have a punitive president who likes to retaliate, so you have to keep that in mind. But no, I think at this point, my guess is no. We have the U.S. Chamber of Commerce had filed a brief. They were one of the amicus on the original lawsuit, and I think that gives pretty broad breadth to the business community as a whole. So I would be less concerned about retaliation, and I think right now my own advice would be to lean into it. Um, but it could also be just that I'm frustrated with the tariff structure at the moment.
Yeah, Alex, I actually had a client who I counseled on that particular issue, and they decided not to file the lawsuit because they were significantly concerned. Now, most of their refunds were due to China origin goods, so I think that entered into the equation somewhat. But it's a judicial process that the courts are going to handle, so there'd be no specific retaliation through that process. But Brian's point is more important, that you never know what the administration may do to a particular company. FedEx just filed the lawsuit, so I defer to Alex and Brian if they've heard anything about the administration reacting to that. But if you don't get a reaction in terms of FedEx, smaller and medium-sized businesses might not run the same risk.
I'll just say, I was talking to Alex before. We've spent a lot of time at NAW working with a lot of our other trade associations in the last 24, 40 hours, trying to get the business community to act as much in lockstep as we can, so that we don't leave friends behind here. So I think this is a political moment, also an opportunity for us to wear our coalition hat and try to get everybody to jump at the same time. That's what we're working to do.
Yeah. I think we have time for a couple more questions. One that I can answer right now. This webinar will be recorded, and also Eddie's slides will be available to be shared. So you will all see that in your inbox, I think 24 hours after this webinar. One other question, Eddie, and maybe I think this might apply to all tariffs, not just 122s, but can you remind folks when a tariff is imposed, in this case 122s, does it apply based on the shipping date, the arrival date? What's the actual specific time that those usually take effect?
Yeah. So they're effective immediately upon the issuance of the customs guidance. And I listed the customs number there, so you can look it up. But there is an on the water exception. So for certain goods that were discharged at the port of export and that were on the water on their final voyage to the final destination, the tariffs would not apply to those. The specific language is in the customs guidance. That was the same language that was in the IEPA orders. And I had several clients who actually got into disputes about that with customs, and those disputes are still winding their way through the administrative process, because some of them discharged in Canada to rail, and then it came into the United States. But because customs took the position that because you didn't discharge on U.S. soil, that it didn't apply. So there's some nuance there, but they apply immediately, Alex, unless you satisfy that exemption.
Okay. And then on the question of refunds to customers, even though you're not the importer of record, there's been a couple of follow-up questions. So just to clarify, really, if you're kind of not the importer of record but purchasing from the importer of record, there's no kind of process similar to the refund process absent a contractual agreement.
That's a fantastic question, actually, and that gets to the things that this court is going to have to address, and why I think a special master may be may be lined up for this, because those kinds of questions, technically only the importer of record can receive the refund. But that doesn't mean that others don't have valid claims, that, hey, look, they passed it on to me and I paid it. How the court deals with that will remains to be seen. But I could see a world where there's some kind of proof maybe that you can present to a special master or to the court, suggesting, well, look, I paid the tariff, and here's the correspondence from the importer or someone else in the supply chain who said specifically you're paying this. Then do you have to then just rely upon and hope that the importer of record, in a sign of good faith, is gonna pass that savings back to you? I don't know. But that's where that's just a wonderful question, and that's where the court's going to have to get involved, and that's where the equities are gonna fall in place, because and again, that may be something that the political winds tend to influence. And I don't know, Alex, if any of those bills that you mentioned address those kinds of issues, but if they don't, I'm sure you'll see some of them try to address that.
Yeah, I think most of the bills so far, they're just kind of very much scattershot messaging bills from Democrats, and I think a lot of them focus on requiring the government to repay all of the refunds within a certain amount of time. So I think that's probably a level of granularity they haven't gotten into yet. I think last question before we close. So this one company is mostly an EU importer, but they're wondering what period of time does the IEEPA refund cover? Is it from when, and I think this is relevant given over the past year, the many changing tariff policies, would this impact from when they first began imposing tariffs under IEEPA, and it doesn't matter that they kept changing and having trade deals that lowered rates and changed rates? Can you speak to that, Eddie?
Yeah, from day one, when the president issued the executive order and when customs issued the guidance to start collecting, that's the starting point. Now, it's an open question. Again, your audience has raised some really important, interesting questions. The deal with the EU was that sort of IEEPA light, or were they still, was that negotiation intended to replace the IEEPA tariffs? That is unclear. And so, do we hit a stopping point at the date that the EU and the US reached that deal, and the US stopped collecting the IEEPA and started collecting these? That remains to be seen. And there's another argument that, well, the EU didn't ratify the deal. The agreement has not been ratified, so technically, I guess it's not an international agreement. It's probably still binding, depending upon, this is getting into treaty law and things like that. But if it were me, I would assert the claim from the date of imposition through the date that customs stopped collecting, and there'll be some guidance on that down the line. So if there is overlap between IEEPA and what you're paying on EU specific, then I'm sure customs will clear that up.
Great. All right. I think we've covered most of the questions. Eddie, thank you for joining us. As always, appreciate your insights. Brian, do you want to?
Yeah, I just want to thank everybody. I know, Eddie, thanks a lot, as always. We in AW, we work with Eddie. He answers all of our questions throughout the year, all the time. And so we appreciate it when he takes time and does it with us. But also, Alex, well done. I know there's going to be more questions as we go forward. Everything's changing and evolving. And so as we learn things, we will pass them on to you as we see whether somebody challenges 122 and the constitutionality of it, whether there's when new tariffs come out. We'll keep you updated on that. You all please keep us updated as well with questions that you have, and certain concerns. If Alex or I can't answer it, we will pass them on to Eddie, and we will make sure that those get answered. So please keep that feedback loop going. And with that, I just want to thank everybody for tuning in. As I mentioned in the intro, in the next 24 hours, you will get a link to this to be able to watch it again and see just how amazing Alex and Eddie are. But feel free to forward that. If you're watching it on the replay, next time, we'd love to have you come live. And thanks again. And that concludes the webinar. Appreciate it.
Thank you, everyone.